What if you make,
I
we are live here.
live now. And okay, and I see that they have me and Andy on the screen, which is what it should be. All right, so I'm calling to order the meeting of the Democratic Commissioners pursuant to subdivision 13 of section 2-122A of the election law to determine the Democratic candidates for president on the primary ballot. Bob Brem, would you read the resolution that has been proposed?
Yes, can you hear me?
Yes, we hear you fine.
Yes.
Great. Resolution related to determination of publicly suspended presidential campaigns pursuant to section 2-122A of the election law. Whereas pursuant to election law, section 2-122A, 11 designating petitions were filed with the State Board of Elections, designating 11 candidates for the Democratic presidential primary. And whereas numerous candidates for delegates pledged to certain presidential candidates also filed designating petitions with the State Board of Elections or applicable local boards of elections. And whereas since the filing of these petitions, 10 presidential candidates have publicly announced that they are no longer seeking the nomination for the office of President of the United States, or that they are terminating or suspending their campaign. And whereas election law section 2-122A, subdivision 13, provides that if a candidate for office of the President of the United States publicly announces that they are no longer seeking the nomination for the office of President of the United States, or if a candidate announces that they are terminating or suspending their campaign, or if a candidate sends a letter to the State Board of Elections indicating they no longer wish to appear on the ballot, the State Board of Elections may determine that the candidate is no longer eligible and omit said candidate from the ballot. Provided, however, that for any candidate of a major political party, such determination shall be solely made by the commissioners of the State Board of Elections who have been appointed on the recommendation of such political party or the legislative leaders of such political party, and no other commissioner of the State Board of Elections shall participate. And whereas election law section 2-122A, subdivision 14, provides that if the presidential candidate is removed from the ballot, the delegates pledged to such candidates are likewise removed from the ballot. And whereas pursuant to election law section 3-100, the commissioners adopting this resolution are the appointed Democratic commissioners, and as such are authorized to determine that a presidential candidate for the Democratic nomination is no longer eligible as a designated candidate. Now therefore be it resolved that pursuant to the public declarations made by the relevant presidential candidates, the following candidates are no longer eligible as a designated Democratic primary candidate, and their name shall be omitted from the Democratic primary ballot. In an alphabetical order, that's Michael Bennet, Michael R. Bloomberg, Pete Buttigieg, Tulsi Gabbard, Amy Klobuchar, Deval Patrick, Bernie Sanders, Tom Steyer, Elizabeth Warren, and Andrew Yang. And that's the end of the resolution.
All right, thank you, Bob. So I want to make it clear that this was a very difficult decision because we have gotten so much feedback from so many supporters of Bernie Sanders. And I have actually read virtually every email that was sent to me, even though it was several thousand. And I certainly understand why so many people want to continue the presidential primary. But we're dealing with a statute where the statute specifically says that if the candidate has announced that they're suspending their campaign, that they can be removed from the ballot. And Senator Sanders has not only announced that he suspended his campaign, but he's also announced a public endorsement of Joe Biden. So that has effectively ended the real contest for the presidential nomination. And what the Sanders supporters want is essentially a beauty contest that, given the situation with the public health emergency that exists now, um, uh, seems to be unnecessary and indeed frivolous. The governor, exercising his emergency powers, canceled a number of special elections, one for Queensborough president and several for vacancies in the Senate and Assembly, because he reached the same conclusion that while elections are very important in those particular contests, uh, where there are primary elections going on at the same time, that there's confusion of the voters and that they serve no significant purpose at a time where it is better for us to be conserving our resources. And with that in mind, I think that it's time for us to recognize that the presidential contest is over. I'll add another thing, that I've read the letters submitted by the official representative of the Sanders campaign. And that letter, which I've carefully reviewed and considered, contains one factual inaccuracy. The factual inaccuracy is that, in fact, the legislature passed the law, which we've cited, on April 3rd, and the governor signed it into law on April 3rd, which is before the April 8th announcement of Senator Sanders that he was suspending his campaign, and before Senator Sanders' public endorsement of candidate Joe Biden. And then in many of the emails that I received, it showed me that people did not understand the technical procedure for electing the delegates to the Democratic convention. And I won't go into those technicalities now, but the fact is that the number of delegates is elected by the presidential preference, and that in fact delegates pledged to the same candidate are actually running against each other and not against the delegates pledged to other candidates. So given all of that, I endorse and support the resolution as Bob Brim read. And I'll turn it over to Commissioner Spano.
Yeah, I thought very hard and long about this. In fact, I only came to a decision this morning. I felt that weighing the possibility of people going to the polls or voting or doing whatever and having to be in the situation of deciding whether they were going to vote or whether they were going to get themselves in a position where they might jeopardize themselves. I thought that, especially for our workers, the workers in the various places and polling places. This morning, looking at the fact that the governor had just recently said that everyone could be mailed an absentee ballot, looking at the fact that it would minimize the number of workers that had to come out and be in close quarters for a long time, not only running the elections, but getting the various tallies and tallying them up. And looking at the situation in Wisconsin and seeing those people on the lines and being myself locked up in here trying to avoid getting any kind of any kind of contagion. I've come to the conclusion that we should minimize the number of people on the ballot, minimize the election for the protection of everybody, but give the opportunity to vote in the actual elections for candidates and not have anyone on the ballot just for the purposes of issues at a convention. So I agree. I'm voting for the resolution.
All right, well, given that both commissioners have approved the resolution, so that stands, and I believe that's all the business for the Democratic commissioners.
Can I just clarify for purposes of the voters, does this mean there'll be no Democratic primary for president in New York?
That's right. That Joe Biden is the only candidate, and therefore he has effectively won the New York primary.
Okay.
The state board will also send out an amended certification saying what you just confirmed.
Okay, so that concludes that portion of the meeting, and I guess we're ready to start our regular commissioners meeting with Peter Kuczynski.
Okay, I will open up the meeting then. My name is Peter Kuczynski, and we have Commissioner Kellner and Commissioner Spano here for the Board of Elections meeting here on Monday, April 27th, and we're starting that meeting now as a full board. So the first order of business are the minutes of February 28th, 2019. That was our last full board meeting. I received some minutes this morning. I did have one small amendment I wanted to make to them. I don't know if that's been made. If not, we'll just put off the approval of these minutes until the next meeting. I don't know where we stand exactly with the minutes.
I haven't seen the revision yet.
Okay, then I think we should put it off. I mean, if they could, it was a small thing. I think one item was just left off that needed to be included. So why don't we just put off approving those minutes until the next board meeting, if that's okay with the other commissioners? Okay, so we'll do that. And then when the staff gets a chance, just circulate that changed agenda or I'm sorry, minutes, and we'll take it up at the next meeting. So the next order of business on today's meeting agenda are the unit updates, and we will begin with the executive unit, that'd be Bob Brem and Todd Valentine.
Just one recommendation, if it's possible. We have 140 or more determinations to make. Is it possible to perhaps take those out of order so that we can start to get those
Sure.
shipped out to the various people? I mean, do whatever you want, but that might help us meet the UPS deadline today.
Yeah, we could take that. That's the first new order of business. That's the proposed determinations of the petitions that were filed for this year's election. And we have I'm just trying to see if I can find here, we have a complete list that was provided to us by the staff of all the determinations based on the hearings and prima facie decisions that were made, or recommendations, I should say, that are made by the staff to the commissioners for approval today. And there are, I don't know, how many are there? 140, you said, Bob?
Yep.
140 separate determinations, some valid, some invalid. I don't know if any of the commissioners have any questions regarding them, but they are provided to us as a proposed document by the staff. Is there a motion or a discussion?
I had one issue with respect to the objections to the LOTA petitions. That the report simply says that we're deferring this because there's a court proceeding, and yet I think we should be ruling on it. I'm sorry about that. The objection itself challenges the eligibility of the candidate because the candidate is the Suffolk County Elections Commissioner. And Election Law 3-200 Subdivision 6 says that an election commissioner shall not be a candidate for any elective office which he would not be entitled to hold under the provisions of this article unless he's ceased by resignation or otherwise to be commissioner prior to his nomination or designation, therefore. Otherwise, such nomination or designation shall be null and void. And in this case, Commissioner Lalota submitted what purports to be a leave of absence, but he hasn't followed procedures to take a leave of absence. And it's not so clear to me that even if there were a proper leave of absence, that would satisfy the provision of the election law that that no commissioner shall be a candidate. And I might add that he's still listed as the Suffolk County Commissioner on our own website, and that in his purported leave of absence, he reserves the right to resume his status as commissioner at any time, which puts him in effective control of the deputy commissioner, which is certainly contrary to the statutory intent. So therefore, I move to amend the report to find that the objections to the Lalota petitions are proper and that the candidacy is invalid.
Is there a second to that motion? Hearing none.
I think Commissioner Spano is trying to speak.
Oh, I'm sorry. Commissioner Spano, did you have something to say?
Andy, we don't have.
I can't hear Commissioner Spano.
You've lost the audio again.
Yeah, I'm still not hearing Commissioner Spano. Does anyone know, is Commissioner Spano, are you trying to speak and we can't hear you, or I don't know the status?
Yeah, we've had trouble with this before earlier today.
Okay.
So he'll figure it out and get back on. So we just need to be patient.
Okay.
He's unmuted on the participant list.
Yes, I see him as unmuted as well, so.
Okay. Go ahead,
Could I be heard on the motion? Could I be just heard briefly on Commissioner Kellner's motion, even though?
Well, can we wait just a second, Kim? I'd like to see if we have a second on it before we discuss it.
Okay. You just couldn't hear me either for a minute, so we're trying
I'm sorry. Okay. Yeah, no, certainly if there's a second, we'll discuss the motion. Absolutely.
Okay.
Yep. Okay. Go ahead. I'm just waiting for Commissioner Spano to, I guess, technically get himself.
Get everybody off and bring them in here then. It'll lower the bandwidth. Can he call in? Call him on your cell phone. I will.
Yeah, because you could just link his audio right from, you could conference him in right from the boardroom phone.
Can you hear me now?
Yes.
Yes, we can.
Now we hear you.
And we can see you.
They can see me and hear me. I'm having a bandwidth problem. That's what's happening.
Okay. Okay. So Commissioner Spano, the situation is Commissioner Kellner's made a motion and I asked if there was a second.
What was the motion?
This is on the Lalota petitions.
Okay, what was the motion?
No, he's talking now. He just asked what the.
Commissioner Kellner, could you repeat your motion?
The motion was to revise the staff report on the petition determinations to rule that the objections to the Lalota petition are sustained and that the Lalota petitions are invalid on account of his being the Suffolk County Elections Commissioner.
Can you hear me?
Yes.
Okay, I support the motion.
You support, okay, so the motion's on the table. We can have discussion. I guess Kim Galvin had something she wanted to offer. Kim, you have something? No? I'm sorry, is Kim on? Because I thought she had said she had something she wanted to say.
I do. I do. I'm
Go ahead.
sorry.
Do you want to speak in? Feel free to speak in relation to the motion.
Okay, as we all know, petitions are presumed valid when filed at the Board of Elections pursuant to 6154-1. Mr. Loda's resignation, if you will, or leave of absence, I'm sorry, I misspoke, is the subject of intense litigation down on Long Island, and there's also a case, I believe, up in Albany challenging an authorization to one of his lines. As with most matters that are illegal, legal interpretations of a statute that's already in court, it's our position that the staff position that we defer to the courts for the determination.
Okay, well, that would explain why the recommendation from the staff on the report I have is that it remained valid. You referenced that there is a challenge to the candidate's qualifications in court. There's some litigation apparently that is ongoing, as you've mentioned, and that I think will determine the outcome of this. I think, as Commissioner Kellner indicated, there's some uncertainty here. I think this may be a case of first impression. I'm not aware of another case like this, and I understand there are some factual issues here related to Commissioner Lalota's efforts to take a leave of absence in order to address the issues within the statute. And I think that those facts are largely the subject of the litigation. In that regard, I think the litigation is appropriate, and I think it would be best if the courts determined the outcome of this rather than this board. I think this is beyond the reach of this board to make a legal determination regarding qualifications of a particular candidate under these circumstances. So I will call for a vote on the motion to remove this and change the recommendation from the staff. So on the motion, is there any, I'm sorry, before I do that, is there any other discussion?
I just want to say something. I feel very strongly about this. Because that you yourself mentioned that this was something that wasn't totally in your purview, and you've been around a long time. And I just think that the law is set here and I've been around a long time too. The law is set here because they don't want commissioners of elections getting involved in this way. Just take one of us. I mean, why? I'd like to run for Congress. So what I'll do is I'll just give myself a leave of absence and I'll go and run for Congress, or I'll get two of you guys to vote for me. This is ridiculous. That law's in place for a reason. And the other thing is, politically, if he wants to run, he should just resign, go to his party and tell his party he's going to resign. This guy's his deputy is going to take charge for a little while. And if he loses the election, tell him to reappoint him. Send it to the Board of Legislators and tell him to reappoint them in Suffolk County. I mean, he's got some political ways to do this. He wants his cake and eat it, fine. But I just feel very strongly about this. And I wouldn't care if he was a Democrat. I'd be saying the same thing.
Fair enough. Okay. Any other discussion? I see Commissioner Spano feels strongly about this. And if there's no other discussion, I would call the vote. All in favor of the motion, say aye.
Aye.
Opposed? Nay. I believe the motion fails for a lack of a majority, which would be 3. And the recommendation of the staff remains as is. So we now have the full document in front of us of all of the staff recommendations regarding all of the petitions that were filed at the board. Is there any other discussion regarding anything else on that report? And if not, I would entertain a motion to adopt the report as submitted. I don't hear a motion. Are there no motions to adopt the report?
I will unmute. All right, I so move, and On the question itself, obviously, I've made known my views with respect to the Lalota petitions, which should be, they really should be separated out from the report.
Fair enough. So I'll accept that as a motion to adopt. Is there a motion to adopt? Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? Okay, so the report is adopted by the board. And now that we've taken that out of order, we'll go back to the regular order of business. I'm sorry, I need to make sure I'm on the right page here. Okay, so that then addresses the first new business ballot access rulings. We will now go back to the unit updates and the executive, Bob Bremen, Todd Valentine.
All right, good afternoon, commissioners. As you can imagine, there's been a lot going on, and I just wanted to quickly run through, the executive orders that have impacted us lately. There's been 4 major executive orders that impacted elections directly, starting with Executive Order 202.2, which suspended the gathering of designating and independent petitions, which also was extended by 202.13. And then 202.15, or 16 rather, set the date for June 1st for when caucuses could start to be held. So, just looking at this from the village election perspective, essentially they've postponed the March and April village elections by Executive Order 202.13.
Todd, I'm sorry to interrupt. Maybe we could do this a little different way. I think
Okay.
The governor has issued a number of executive orders, which you identified. I think it would be helpful if we could sort of segregate the different issues that the governor has issued executive orders on, and we could take it issue by issue, and then we could understand the current status of the law as it relates to that specific issue. So, for example, I think village elections are one issue, designating petitions are an issue, independent petitions are an issue, absentee ballots are an issue. So, I think it would be helpful if you took it issue by issue, and then you could just tell us what the status of that issue is that's been changed by the executive order. I believe I see Kim Galvin raising her hand like she wants to say something in relation to my suggestion. Kim, what do you think?
I'm going to offer to Todd that I'm prepared to do that if he would prefer.
I see. I don't care who does it. I just think it'd be helpful to go through it issue by issue rather than just jumping around, because I think it would help us keep, a better idea of exactly where each issue stands. So, Kim, Todd and Kim, however you want to do this.
Well, I'm just going to touch on the major issues as you talked about, which is what I started to do, and then then Kim can fill in with some of the details. But essentially, and these are not in lack of priority, but they are just issues that we've identified from the executive orders. One is the village elections, both for March and June. The March, and there are some village elections scheduled in April. Both of those are suspended, but have not been rescheduled at this point. The June 16th village elections are still on schedule, but the ability to get on the ballot for those elections has been interrupted. There's no provision for independent petition signatures for those village elections, again, sticking with villages. And the time to do a caucus for that village election does not begin to run until June 1st, but the normal time for filing those would have been back in April 23rd, so the time frames aren't working. So village elections are in unknown territory. Town caucuses going to the next level. The date for town caucuses under one executive order, 202.13, was said that they could commence in the normal process on June 1st. That works for town caucuses as they have until July 23rd to file. Some may have done it beforehand, so those are currently in an operable state. Independent petition signatures for looking at the federal, state, and local levels. The gathering of those has been suspended pursuant to executive order Our regular independent petition period would have begun on April 14th, and then the filing period would have been May 19th through the 26th. So there's currently no way for independent petition signatures to go forward for those offices.
So I'm sorry, Todd, could we just talk about that? So independent petitions would have started when?
April 14th was the first day to sign the state.
And the governor has done what? He suspended the independent petitioning process?
Right, pursuant to 2 separate executive orders, the ability to gather those signatures has been suspended.
Just suspended though, so there's no new date for gathering independent petition signatures. Is that what you're saying?
That is correct.
Okay. So right now, independent petitions are not able to be circulated in New York for this year's election.
That is correct.
Okay, so that would take a subsequent order to reinstate that, or how would this end up?
Either a subsequent order, or as we saw with the designating petition period, there was an act of the legislature that truncated and made the filing period a different date. So it could be one or the other.
So is there some agreement? Do you think there's some agreement then that it takes the state legislature to reestablish petitioning periods, that it's beyond the scope of the governor's power? Or why did the legislature take that action vis-a-vis designating petitions? Do you know?
I don't know why. I mean, we've raised the issue, but we don't necessarily have an agreement as to what the next steps would be, other than it needs to occur at some point.
Okay.
And there is some time to do that because obviously these are petitions that put right on the November ballot. So our date to certify the November ballot is not until September 9th. So there's a window here in which that process could begin or get started again. It never got started, could get started and then filed in the normal course of business.
Okay.
Whereas the designating petitions, in order to stop the process as where it was, really needed to have some truncated version of the filing process and a reduction in signatures. So there are a couple issues that are related to that. When it gets done, do you do it the normal course? And is there if you don't do it the normal course, do you reduce any of the signatures?
Okay.
Obviously, the April primary, as we've just talked about, was originally pushed to June, and along with several special elections, the only ones that are still left standing at this point, based upon the most recent executive order from Friday, is the congressional vacancy in Congressional District 27, and then my understanding was that there's also a city council one special election that wasn't dealt with, while the Queen special wide was dealt with. So
what was canceled?
What was canceled were Senate District 50, the Queen special election, and then there were 4 Assembly District 1s, Assembly District 12, and then the other numbers escape me. There's one in Queens, and one in Rochester, and then I'm missing one.
Okay, so it canceled 4 Assembly, 1 Senate.
Suffolk.
Okay.
That's 12.
Okay.
The New York City Council vacancy was canceled today in Executive Order 24.
Okay. So the only special election still ongoing is the 27th Congressional District?
That's correct.
Okay.
And along with that there's been no change as far as the election is concerned. There's been no reduction in the days of early voting. There's been no change to the election day itself. It's still on. The process to vote in person is still on. And then that leads us to what has changed a couple times is the process for absentee voting. And I know Commissioner Spano mentioned it earlier. It's like the ballots themselves are not being sent out. So we just want to make that clear. Under the current executive orders, at least the most recent one from 202.23 from Friday, requires that boards of elections mail an application to the active and inactive eligible voters for the upcoming primary election, the June 23rd, which would also include the special election as well. And with that would be included a postage paid return envelope so that the voter could complete the application, sign it, and then send it back. And then the board would then send out the ballot itself, which would also include postage paid for return. So they would have to do not postage paid. You're saying no, you're shaking no to me, Bob.
That was not in Executive Order 23rd. That decision hasn't been made yet.
Okay.
Return
So
of the ballot itself.
But they would still send the package out based upon the application. Thank you for correcting me, Bob. As we stand today, the boards are, and we're working on the process of working with the Postal Service to, so that they can understand how to do a mailing like this. Now, they've mailed applications out before, of course, but it's the postage return envelope, which is a different mailing that has to occur. The boards don't have envelopes that are printed for that. Right now, their return envelopes required to put a stamp on it. So that would be a change in the process for that. And it still leaves questions of the prior order as to, the prior executive order had expanded the definition of illness under the statute to include the prevalence and community spread of COVID-19 as a reason for applying for a temporary illness. But it also suspended the signature requirement with an in-person signature. And so it still remained whether that was just applying to the electronic applications, which the current order, again, asking a question, was that it expanded the means of applying. It said continued, but wasn't specified in the prior order, was by phone and internet. And it added additional terms that haven't been defined yet. And what's still not there is also suspended was a prior mailing that the counties had done with regards to their mail check notices. And some of the questions we're getting now is whether they can, since they have to mail the application out about the ballot, applying for the absentee ballot, could they include a notice in there that would effectively become the mail check should that notice get returned? Again, it's a question, it's not answered on there. So we're just trying at this point to figure out how to get the counties in a position to do the original mailing, and then how to process the applications when they come back. And then, obviously if there's an increase in applications, then many of the boards are, due to staff reductions, are not fully staffed at this point. So they would have to process all those, again, getting the ballots out. But then on the back end, they also need to be able to process the ballots as they come back and to be able to do that in a timely manner so that we can get the election results, in a reasonable time period. There may be some delays because if there's more paper, it could take longer to count. Many boards obviously are not set up to automate this process as much as other boards are. So I don't know if Kim wanted to fill in on that.
No, I agree with everything that Todd said. The main change, obviously, and the most contentious change or talked about change is not requiring the upfront signature to receive an application, which would in turn require the boards, presumably, to check the envelope that comes back with the signature that they have on file to somehow match those up. It's going to take a lot of time. The commissioners of the Board of Elections are saying that you won't have election results on election night, or you have to wait the requisite number of days before the ballots come in. There's no timing contained in the executive order as to when these ballots can begin to be opened. We all agree that they can do the research on them ahead of time, but there are candidate notices and things that have to be worked through in order to get this process one that's uniform throughout the state. And all of those little wrinkles are left to apparently the discretion of us to formulate some sort of guidance.
Okay.
This is Bob. I'm not sure because they're absentees, that guidance isn't already in Article 9. I do agree it will take much longer, because the statute deals with already a requirement that a bipartisan team review those returned envelopes to check the signatures. But in the quantities, I think it will be unprecedented. So that I think are the timelines that are proposed in this, or that are existing in the statute, realistic. It will definitely take longer after the election to go through a much higher volume of absentees to do those steps. So with early voting and election day voting, that would be what you would know as the total of votes on election night. But these absentees would be a series number of days afterwards to be able to make the decision to open them and start the canvass of them. And that it would take some time. At a minimum, you receive them 7 days after the election, and then you'd have to start that processing, et cetera. One other bit of information that has changed since the packets went out to the commissioners. The Division of Budget confirmed late Friday and in an email today how the Federal Voters Act election fund will be paid for. The question that held up New York State's application was the appropriation language and how the 20% state match would be met. And Friday night, the state confirmed that the state will pay the 20% match, which is about $4.1 million. And the federal share to the state is just shy of $20.5 million. So today I can update the application. The counties will be the recipients of those grant funds, and the recommendation of the staff had been to allocate the money similar to the way the other HAVA monies had been divided, which was based on the total number of voters on February 21st of this year, the last annual report of registrations and enrollment. So it's proportional to that report. So that's some good news for the counties, that there will be about a little under $25 million made available, and that would help the counties to be reimbursed for unanticipated expenditures for running the 2020 federal elections. So there's a little bit of good news in there.
Yes, Bob, but that's a reimbursement mechanism, correct?
Yeah, the counties right now they would be paying it anyway, and this would allow them to get a contract and a reimbursement voucher.
And that's just for the congressional races?
It says for federal, so for responding to COVID. So I think we're pretty, I know we have a few FAQs we can go through with the EAC, and they published on their website this grant, and they've already answered some of those kind of questions if there are other kind of contests happening.
So I'd just like to add that this is a dramatic increase in cost to the local boards of elections. Not only do they have to mail every registered voter that's eligible to vote in the election and application, that's a cost for the mailing. Then there's the return postage, that's another cost for the mailing. Then there's the mailing of the ballot. So you have 100% of eligibility being mailed out, and we all know that the actual participation rate is significantly less than 100%, and many of the counties are struggling with that calculation, with that money, and also with getting enough ballots. And as Todd mentioned earlier, the envelopes are a real problem as well. The printers have indicated they need 7 to 10 days in order to order the requisite number of envelopes. And then when you mail them out, they're returned, you're running up against, the 45-day deadline for the June 23rd election. So it is a tight crunch for these boards, and it's unfortunate that it took this long for some clarity on what they were going to be required to do.
Do we have an estimate of how many absentee ballot applications will be sent under the order?
I don't believe, just talking with Erie, I can only speak to Erie because Ralph Moore, one of the commissioners out there, had a distinct number for his federal. He has 2 federal primaries and a special election. He has 950,000 ballots that he has to mail for just those 3. So.
Applications.
Okay.
Yeah, so that is, that's a high number. I don't think we have the overall state number yet, but.
But we have an estimate because we know that there are the special election notwithstanding, and now with the presidential primary being eliminated and the other specials, that reduces it down. We know on a state level that 53 of the 62 counties have either a Senate, Assembly, or congressional primary, or all 3, plus all the counties that have local primaries. So again, the rough estimate we're using is approximately, without knowing the locals, is approximately 7 million voters would need an application.
And what would the cost be for sending those applications out then for the 7 million voters, approximately?
Well, you have to look at, for each mailing, it's postage both ways, approximately 50 cents, so it's $1 plus. So you plus the cost of the printing and obviously the extra envelope that you'd have to print,
Okay.
somewhere in the $2 range for the mailing to go out, because that's the expected cost for a 3 envelope absentee package. So this would be a equivalent, a little less than that. So it's probably a little less than $2 a package. So times, if using that as an estimate, so it'd be at least $14 million.
Okay.
Well, it's not everyone coming back, I assume. So it would be 50 cents for everyone that's mailed out, and then it's postage paid for the returns. So you're only paying for the returns.
Sure.
So
Okay.
that is, so if we use a 7 million going out, is it a 50% return? Is it a higher in some places and lower in others? But I think, somewhere in that range. And then, of course, the ballots themselves will have to be mailed. And then the cost of mailing the ballots out always depends on size and weight of the envelope. So the application is probably an easier thing to figure because it'll be more uniform in weight and size. The ballots might be different depending on what part of the state you're in, how complicated the local election is it a 2-page ballot, et cetera.
Okay. Now, I've read a couple accounts, and I just want to get this clarified, that the governor's office has issued a couple statements I saw where it was the State Board of Elections obligation to send the applications out. Is that our understanding? I mean, I didn't understand it that way, but I just read a couple statements from out of the governor's office saying that he'd ordered the State Board of Elections to send a absentee ballot application to every voter in the state.
That's not how the order itself reads.
Okay. So it's the county boards that'll be obligated to do this. Is that correct?
That's our understanding. Yeah.
Okay. Okay. I just wanted to get that clarified. Okay.
And we're scheduling a call with the U.S. Postal Service and the county boards for tomorrow. We had a preliminary call with staff on Friday in anticipation of the order to make sure that we can get that return postage permit. Not too surprising, the U.S. Postal Service has different return postage codes for election material related to, like, the government election material. So there's a different return postage code needed for the absentee ballot application. And if they're going to order the ballots themselves be return postage paid, the post office places a higher priority on returning or moving ballots through the mail. So the code for the ballots is different than the code for the absentee. So we have to work with the counties to update their sample envelopes so they can go to printers. And that has to be done really, really quick because Kim mentioned the printers need, a real order for a real quantity so that they can jump on getting this many things done. and no county has used postage paid return envelopes for this kind of mail. So we have to work really, really quick with all of them to update their samples that would be acceptable to the post office to move the mail through it.
Okay. So I have a couple questions myself on the process, I guess, that we're going to be anticipating here. So as I understand it, the order, first of all, orders that a absentee ballot application be mailed to every active and inactive voter in the state. And I'm presuming that means those that are eligible to vote in the June 23rd primary. So it won't be every voter. It would be every voter who is eligible to vote in one of the primaries or one of the specials in the state. So I assume that's going to happen. Then there was another part that allowed for internet requests of absentee ballots and also phone requests. So I'm trying to understand how that works. So I guess, is it our understanding that if you want a ballot, you can just pick up the phone, call your Board of Elections, say, I would like you to send me a ballot for this June 23rd election. My name is Peter Kaczynski. I live at such address. Please send me a ballot, and that would be sufficient?
I believe so.
Yeah, I think based upon the prior order allowing the extended or the lack of signature, I think maybe the way that Kim phrased it, or the absence of the signature, that they would be able to, when the phone call comes in, obviously the board will have to document the information that's essential to identify the voter, to identify which election, so they know which election they're eligible for and where to send that information. And obviously, you know, there has to be some type of bipartisan communication with that process to validate that, you know, the call actually came in, that it was a legitimate request. It just uses the word phone, so it doesn't go into that process that's behind that. But there has to be, some of those concepts have to be put in place to work within the existing system.
So if I made that phone call, could I ask for more than one absentee ballot? For example, could I request a ballot on behalf of other people? Could I make a call and say, listen, I've got 10 voters that would like their absentee ballot sent to them. And I'll give you the names and addresses. And could I, as a voter, as a person, call and make 10 requests that would prompt the board to send out 10 ballots? Just for example,
That's a good question. You know, that one of the things that I know I don't have an answer to, you know, it's usually an application is from a voter, and this is a request. If they were just requesting an application, that would be one thing, but now it's the application itself. So, you know, the statute envisions that the application coming from the voter, but I don't know what the answer is to that question.
Okay, and how about like the internet, I guess? So there's internet requests, same thing. Could I just send in a request over the internet saying, requesting 10 ballots be sent to the following 10 people, and just make that request over the internet? I mean, I guess there's no signatures required either through the phone or over the internet. So could I make those requests on behalf of others? And maybe that's a rhetorical question based on what you said, but do you have any answers to that?
I mean, I think it's the same issue, you know,
Okay.
when it's not the hard copy coming from an individual voter, and it's unclear what the answer is.
Okay, fair enough. So my next question is, if I'm the county board, I'm sending a voter, every voter who's eligible to vote is getting an absentee ballot application through the mail. If they return it by return postage, does that application have to be signed?
I would argue that it would.
So if I make a phone call, it does not, but if I do it on paper, it does. Is that a fair reading of how this will work, or what's the anticipation here?
Well, I think logically, if you send someone an application and they fill it out and return it via the mail, it's legitimate to expect that they would sign it before they put it in the envelope versus sending an email or a call where there's no ability for them to have signed it.
Okay.
This is Brian. Can I be heard?
Absolutely. Go ahead. Sure. Go ahead.
That was actually more of a literally, is my computer letting me be heard question. Thank you, Commissioner.
Go ahead.
I just wanted to point out some words in the most recent executive order that I think shed some light on your second to last question with respect to whether or not an agent can request ballots on behalf of other people. The language in the most recent executive order does say this shall be in addition. This is referring to the mailing of the applications. This shall be in addition to any other means of requesting an absentee ballot available. And then it says, comma, and any voter shall continue to be able to request such a ballot via phone, internet, or electronically. I think the statute read in conjunction with the executive orders, the application process is from the voter to the board and is not, I don't see any language that would create a third party situation where somebody can request a ballot on behalf of somebody else.
Gotcha. Okay. Okay. So you think the order limits my phone call to me? I can ask for one on behalf of me, but not anyone else.
I do believe that.
Okay. Okay. Okay.
I concur with that too, but I want to point out that 8402A provides that application forms shall also be supplied upon the request of the person authorized to vote, or any such person's spouse, parent, or child, or a person residing with the applicant as a member of the household. So that applies to requesting applications, but it does offer some guidance, in the existing statute in terms of indicating who should be allowed to make requests.
Okay. I mean, I think there's a difference in being able to request an application as opposed to being able to request a ballot itself. So I think those are two different things myself. I agree. I agree.
But it gives guidance.
Okay. Fair enough. Fair enough. Yeah. I'm just trying to understand how this, so is the expectation here that this board, our board, will be issuing guidance to the counties so there will be some uniform application? Because I think, I read the orders over, they're pretty bare bones. As we're discussing, there isn't a lot of detail on some of the applications of this. It seems to me it would behoove us to give guidance to the counties so that there be at least some universal applications of these orders across the state. So we're not seeing some counties treated some way and some counties treated a different way. I don't know where we are in doing that, but I think the staff, if it can be done, should try to come up with guidance and identify these issues and then give answers to the boards as best you can to assist them in doing this uniform application of the law. That's what I'm trying to get at.
Yeah, that's certainly our intent, is to put something together as we try to always educate the voters, or the boards rather, to try to have as much uniformity as possible. I mean, there's always there has to be some local flexibility, but that's what we aim for. And, we haven't gotten to that point because, again, it only came out Friday night.
So is there going to be a change in the application itself? I mean, it seems like this order, the one that allowed people to apply for an absentee ballot based upon the, and I don't know the exact word, I don't remember the exact wording that was used in the order about the pandemic that would qualify, that concerns about it, or what was the language? Do you remember?
Yeah, 1 second.
Potential for contraction.
Potential, so that a voter who feels they have the potential for contraction would have the ability to apply for an absentee ballot. And I guess that means they're somehow fitting it into the illness allowance for absentee ballots under the Constitution, because as we know, there's only 3 conditions under which a voter can get an absentee ballot pursuant to the Constitution. So I'm guessing that language they're fitting into the illness category, even though the people aren't ill, but I guess this is being fit into that. Is the application being changed in any way to reflect this new qualification, I'll call it, or are people just expected to understand that the illness portion includes this particular concern?
The order said those would be the fear or the potential in a pandemic for contracting or sharing the virus was reason enough to check off the box temporary illness. So it would not need to change the form to come up with any different kind of category other than it would be inappropriate and you'd be able to sign it to say temporary illness, and we would move forward with the form we already have and is translated in the various languages. So we wouldn't need to make a new form. We would just need to help explain the order.
So one doesn't have to actually affirmatively say anywhere, it's this concern of contracting the virus that's causing me to apply. We would just infer that if someone checked the box illness, that they're either actually ill, or they have this concern, but you wouldn't have to affirmatively say that.
That's correct.
I got you. Okay. Well, this is going to greatly increase the number of paper ballots out there. I mean, I will tell you, I have my concerns. I've articulated these concerns even to the second floor, and Commissioner Kellner and I have spoken about this briefly, that I have a lot of concerns about this. I think that we have now tremendously expanded the ability of people to get paper ballots out in the community. I think that's no small feature. I think when we have limits, I mean, frankly, the Constitution has limits on the ability to get absentee ballots for a reason. It has limits because of the concern that putting this number of paper ballots out on the streets lends itself to all kinds of problems of whether it's fraud or whether it's coercion or whatever it is. And so the Constitution has provided this limitation. The governor's orders have now really lifted that limitation. It appears now the intent is to make literally everyone in the state who wants to get an absentee ballot to be able to get one. And so that, I think, will be utilized. I expect it to be, and it will tremendously increase the amount of paper that will be out there, paper ballots, I mean, that will be out onto the streets and out there in the communities, and all the concerns that raises about keeping the integrity of the election together. And as we know, we've spent a lot of years in this state putting together an election system to protect the integrity of the ballot. And in essence, I think what we're doing now is saying we're not going to really rely on that anymore. We're going to allow people to file absentee ballots. We're going to allow them to vote on paper. We're going to do away with the voting systems in a sense and allow people to just submit paper ballots to the boards. You guys have identified some of the issues that I think the county boards are going to have in administering this from a personnel standpoint, from a security standpoint. But I think there's another concern that people should be aware of, that when you put this amount of paper out into the community, this is something New York's never done. I know people point to other states, Oregon, some other states out west that do all paper ballots, but they have spent years putting together a system that makes sure the ballot is safe and the integrity is protected. We're doing this on the fly. We're doing this all of a sudden. I also know there's a proposal that's been made in the state legislature to basically make no excuse absentee ballot legal and to allow for the Constitution to be amended, I believe next year, that will allow basically what we're doing now, which is saying anybody that wants an absentee ballot could get one without any real, reason given, just that you'd like to vote absentee. I think that's a sea change in the way we conduct elections in this state. I think it runs the risk of having all kinds of problems that are attached, not just administrative, but I also have a concern about the amount of fraud and ill use that these can be made out there on the streets. And I think that that's a concern that should be articulated and people should be aware of. So I understand that there is an emergency situation and that people are, we're going ahead with this, but I do think there are reasons to be cautious about this and to be very careful in how this is administered.
Can I say so? Can you hear me?
Yes, I can.
Yeah. I think that's a bit unfair in terms of looking at it in such a negative way. We're in a unique situation now. Priority is people's lives. And I think the second priority is our democracy. And elections are related to that democracy in tandem. And this is an opportunity we have to keep that going. If we keep denying or pushing our elections out or making them so dangerous that people don't want to come out to vote, I think we jeopardize our democracy. The governor here has given us an opportunity to keep people as safe as possible under the circumstance and preserve the ability for us to vote. And I think that has to be looked at that way. I think it's our responsibility to give guidance to everyone throughout the state, not only on how to handle these paper ballots, but how to handle this entire election. The protections they use, how they set up their organized processes, how they set up the polling stations, how they use their books, how they use their machines. That's our responsibility. I think in this election we should do that, and there are outcomes looking to this. I would like to see if mailing out ballots increases the amount of people who vote. That would be an interesting thing. Mailing out these what you call it. Well, doing the mailing increases the votes, because there are places and there are people who are saying that, and let's see what happens. And you got people, in hospitals, in medical facilities, in other facilities, going way out on this, on other things. We can go out on a democratic process of voting and take a little hardship and try to make this happen properly. The other thing is on the money. I looked at the money when I was making my vote about the Democratic primary. And I said to myself, we just spent on a national level $2 trillion, which amortized into something like $6 trillion, if you want to look at it another way. And we're talking about $14 million to preserve an action of democracy. And that's why I voted the way I voted. I want to make sure this election happens, but I want to make sure it happens safely for everybody. So we should just it's going to happen now. It's been voted. Let's just take it under our wings and let's make it happen properly, as properly as we can, and not worry about these other things. Let's try to make sure they just don't happen.
If I may be heard, I agree with Commissioner Spano's. I agree with Commissioner Spano. However, one thing that the governor by executive order has not done is discuss whether or not there will be a full 9 days of early voting and complete setup of all the poll sites on election day. And if we are urging people to be cautious and to try to move them to paper, I would anticipate that there's going to be an executive order next, maybe, that would reduce the number of poll sites or consolidation of poll sites. And I would just urge anyone that might hear me that we know that sooner than later so that these counties can prepare for that adjustment. We have poll sites backing out all over the state. We have election workers saying they will not come to work. So that is another thing that is still in limbo as far as I'm looking at it, as to whether or not that next order will adjust those things, and we need it sooner than later.
I agree with you on this.
And
I agree with you. And I think that, the mailing of these applications out changes the whole perspective on early voting. And, any way we can get this election to operate properly, we should do it. In fact, I think that we should take the early voting procedures with some variation of it, put that on election day and get rid of the early voting.
Can you give this to Dawn?
I agree with that, we need to keep early voting and election day voting in place because of the imperfections in the mail system, so that people who have trouble getting their absentee ballots or are not able to get them returned safely will have the opportunity to go vote in person. On the other hand, I think that we should start advising counties, even without an executive order, to start arranging poll sites on a consolidated basis for election day voting. We need at least the number of sites for early voting open on election day, but that's not really adequate for everybody because we're aware of the problems of distance, especially outside of the urban areas where we still want people to have access to election day voting, even though we're urging everybody to vote by absentee ballot.
Yeah, but here, right now, you're brainstorming in a public setting. I think that all these issues ought to be taken care of, as we go on the next couple of weeks, and take a look at it and make some recommendations, because there are variations of this that are going to work a lot better. We know we're going to have less staff. We know it's going to be trouble getting polling sites on election day. We know we're going to have trouble with the Postal Service. Let's get some guidance. Let's get some good routines in. And let's do it from here, so we have a centralized discussion and something that's done statewide that people buy into. Let's not leave this to 57 entities going off on their own.
Okay, is there any other discussion? Is there anything else that the staff wants to raise related to the executive orders?
No.
Okay, I think that was a useful discussion. Myself, I had some questions. I think it's been helpful to me, and hopefully it's helpful to the public. And I hope the press is listening, because I think that would be helpful if they were to report the issues and understand how this is going forward. I think we'll rely in part, at least, on the press's ability to report this and to educate the public as to how they're going to go forward with the election on June 23rd. So if there's nothing else from the executive, then we move on to council. Kim Galvin and Brian Quayle.
Thank you, Commissioner. Much of what the council's office has done with the reduced staffing and the compliance unit is we've already discussed with regard to the reviewing of the executive orders, participation in the various components and stages of the 140 rulings that you adopted. We have some things on later in the agenda, finalizing a regulation that we'll get to. One other thing that has raised its ugly head, if you will, Brian and I participated in a WebEx meeting with the New York City Bar Election Law Committee at the invitation of Commissioner Kellner, at which point the discussion of public financing came up. Now, it seems kind of incredulous to me that public financing with a $16 billion debt was a topic of discussion. However, the legislature did codify those provisions, and they are in effect. I just wanted to state for anyone that's listening, and that, the board obviously, I think you all know, has gotten no money whatsoever to begin the process of updating the software. I've gotten calls from groups like the Brennan Center and a variety of other people asking the status. I told them basically, there is no status, call me back. We're busy trying to survive here. But we have no money, not even money to assign people to begin the process of updating the software. We have 3 new commissioners that are supposed to come online on July 1st as part of the campaign finance board. That is my understanding. We have no money to pay for. We have litigation challenging the new thresholds to become a party, which dovetails back to independent nominating petitions. In order to become a party, you have to get a certain threshold amount. In this presidential, you would do that by filing an independent nominating petition. If you can't file a petition, you have no opportunity to become a party in the state of New York right now. So that's another problem that the board has to deal with moving forward.
Okay.
Could I just ask some follow-up questions?
Yeah, sure, absolutely. Go ahead.
Public Campaign Finance Commission. So let's break down what needs to be done, say within the next year, to start the process for implementation. So obviously, one of the things is that the governor and the legislative leaders need to appoint the 3 additional commissioners of the Public Campaign Finance Commission. And then we need to draw up a staffing plan on how we're going to staff this very substantial increase in responsibilities for our agency, right?
Right.
We're talking about staff that may be triple or even quadruple the existing staff of the State Board of Elections in order to fully implement the program. Do I have that right?
Well, there's been internal discussions about how many staff will need it, but we will need substantially more staff and a new office space, because we can't fit the new people into the current spacing that we have.
And it's my understanding that we have some ideas on how to do that already, so that may be feasible, that we'll be able to give that proposal to the budget office by the end of the year when they set next year's budget, right?
With regard to the overall staffing plan, but I think a more immediate need is software money and to get people on board. I don't think that we can feasibly wait until the end of this year in order to start working on that software to have it up and running by November 9th, 2022.
Okay, so the real priority is the software issue. At least the staffing plan is on the to-do list for the agency, even though it is below the priority of getting our absentee ballot system up and running for the.
Right. When the commission first came out with its recommendations, I know many of us sat in a room and kind of brainstormed as to what we would think we would need. We had some disagreements, but basically we all know we need a lot more staff and a lot more space. When it was ruled unconstitutional delegation of authority by the Niagara court, we took a breath. We ramped up with all of these things that you have before you now. The legislature came back and codified the commission's report. It still has that severability clause in it, which is giving a lot of pause. Now, just to go back a little bit, when the commission came out, we went to the governor's office, Bob and Todd, and indicated that we needed the software money then, and we needed it to the tune of $750,000 or something of the like. I thought, well, personally, it doesn't really matter what I thought, but that request was denied, and they said, well, there's a case pending, and there's this, and there's that, and we don't have the money. Okay, now the legislature comes back, codifies the exact same proposals, only now we've lost 6 months of the process. We still have no money. I anticipate in this, it's hard for me to imagine they didn't change the effective dates based upon the financial position of the state, but they did not, which means starting in July, we have increased costs with the commissioners, and we have less time to get the software in order to be ready to go when it goes live.
And then
I just had one thing to mention, if I could. It's uncertain under the fiscal climate we're in that we will be able to spend the money that was appropriated. The Division of Budget said there's a hiring freeze, which is problematic because we have 2 appointments sitting. And it would be problematic if we can't use the money that is appropriated, especially for campaign finance related work, because it's one of those categories that any of the federal funds is not an allowable use for. So we wouldn't have another place to go. So if we lose state funds or the ability to spend them because the state is in a deficit, we may not be able to do the day-to-day stuff we're currently doing, and that's still, we're going to have to make some other priority changes. We don't have those levels told to us yet from the Division of Budget, but it's my understanding that they're going to be quarterly funding levels that we'll have to focus on.
okay,
Yeah, but just this is the same thing that's going to happen every other department in the state government. Same thing is going to be happening to county governments, et cetera. They're all under this kind of so we're not being singled out. We're just going to have to get by with what we have.
All right. Now, there was one other thing that we could be working on in the next year, and that's the regulations. I think we have a year to adopt those regulations. Am I right, Kim?
Yes.
So at least that should be on the to-do list is the regulations, but obviously we shouldn't do that until we have the 3 other commissioners.
And it's difficult to do regulations when you don't really know how the software is going to work.
Well, I guess they go with, you also want the software to conform to the regulations.
Right, they go hand in hand, yeah.
Right. All right, well, thank you. So I appreciate that, and I hope that we'll continue to at least report on the status of implementation of the new public campaign finance law at each of our meetings in the next year. Thank you.
Okay. Is there anything else from the council's office?
Not that I have. Brian, do you have anything?
Brian, do you have anything?
Oh, one other thing. We did have 27 litigation matters regarding the petitions and the filings that we dealt with across the state. Some e-filed, some not. I would like to say that everybody, the judges particularly, were cooperative from their houses. It was an interesting time, but some of those are ongoing. We're expecting at least a few validating proceedings as a result of today's rulings, but other than that, I don't have anything else to mention.
Okay, anything else, Brian?
I would just offer, with respect to public financing, that we have identified all of the key dates for programmatic milestones. And while it will be difficult to figure out how many of those will be met in light of the funding climate that we're currently in, we definitely are working on figuring out what we can do and how we can do it, and have looked at this from cradle to completion. And we'll be definitely keeping the commissioners apprised and taking direction from the commissioners as we move forward, obviously.
Okay, any other questions for the councils? All right, then we'll move on to election operations. We have Tom Connolly and Brendan Lavallo.
Thank you, Commissioner. So for the petition filings for the June primary, Chapter 24 of the Laws of 2020, which was signed back on March 18th, set the dates for receiving petitions from March 17th through March 20th. Obviously, that was in the middle of a lot of concerns regarding social distancing. So the process that for the intake of those filings was altered here at the State Board in order to maximize social distancing and also minimizing the exposure of staff to the filers and the filings themselves. All in all, we received more than 1,700 various filings, including 703 petitions for 1,165 named candidates. We received more than 700 acceptances, authorizations, declinations, and substitutions. And we also received almost 200 general objections, with a little bit more than half of those being perfected with special objections. I want to thank, obviously, the staff for their work under the situation. I think it worked out very well, and I think that all in all, it was a success considering the conditions in which we were doing that work.
Tom, I just wanted to mention, if you have a minute, that I talked to a couple people that participated in the effort that you had, not staffers, but outsiders, and they were very complimentary on the way you guys handled the intake of petitions this year.
Thank you, Commissioner. I'll be sure to pass that on to the staff, because it was certainly a lot of their work as well.
I believe there was even a thought that that might be something we do even under not such adverse circumstances, that it was a very orderly intake and it worked very well.
Okay. Well, we will take that back.
Okay.
With regard to voting machines, I just want to give an update, as I usually do, on the status of the various vendors. For the ES&S systems, the operations unit has facilitated a number of conversations between SLI, who is our testing lab, and also NISTEC, who does a lot of our secondary source code review. And just otherwise, we rely on them for their opinion and review of anything having to do with security testing. that was a very productive discussion. I guess I would categorize it as there was some information that we had received in reports, but it would be kind of like just putting down the answer on a test without showing your work. So NISTEC has kind of just went back and asked SLI for a little bit more documentation and some artifacts having to do with the testing that was performed, which they provided. And I think that all in all, has worked out very well. And so we continue to move forward under those understandings. ES&S also submitted a code drop, as we would call it, another set of source code to SLI for their review, having to make some changes to the ExpressVote XL system. SLI has not yet provided us with any of reports, but as I said, with our conversations, I believe it is underway, if not already completed. They will be providing those reports to us for our review and also for NISTEC to kind of review and take a look over to make sure that there's no other documentation needed. SLI is also conducting an analysis on the new source code and the whole system overall to determine what functional and/or additional security testing might be necessary based on New York State requirements. Before any of that testing is actually executed, again, NISTEC will take a look through it, make sure it's comprehensive and complete before we move forward with any of that. With regard to Dominion, there was a de minimis ECO engineering change order for just some the printer hardware. The printer component inside the ice machines could no longer be gotten, so they replaced that hardware with another piece of hardware. It was just basically a swap in, swap out, and SLI did determine that change order to be de minimis in nature. However, Dominion has submitted a modification to their voting system, which has a couple of just items. There was some changes to, I think, the printer utilities for the ice machine. There was also an update to the software for the older ICP machines to improve ballot processing. SLI has conducted an analysis on what testing would be required for that modification, and it's currently over at NISTEC, and they should be finalizing their review of that information. Clear Ballot, there are a couple of other counties that are looking to purchase that system or are already in process. As a rule of thumb, what we normally would do is we would be going out and doing acceptance testing whenever new voting system hardware is received at a board. Due to the current situation that we find ourselves in, and since Clear Ballot system is usually a lot fewer in quantity, we will be doing some acceptance testing for Nassau County. Here at the state board, the equipment will be shipped here. Our staff will do the acceptance testing of the hardware here, and then the equipment will be shipped straight from here to the board for them to use. We will continue to do that for any other newer customers for the Clear Ballot systems for the foreseeable future until such time that it makes more sense to revert to the older ways where we would send out staff to the boards and do the acceptance testing on site. And then lastly, and this relates to an item later on the agenda, but with regard to the electronic poll book systems that are used throughout New York State, all three vendors have submitted modifications to their configurations for our review, and they are put forth later on for you to consider for your approval. For Knowing and 10X, there were some application changes that were made. And then for all three vendors, they had done some updates in order to bring the underlying operating systems that their systems use to the latest version. For Robus, that would be the Windows system, and then for 10X and Knowing, it would be the latest iOS for the Apple iPads that are used. That is all I have, unless Brendan, you have anything?
No,
Brendan?
I'm good. I think you got it all. Thank you.
Okay, are there any questions for Tom or Brendan? Okay, I just have a quick question about whether the current problem staffing under these circumstances, under these conditions, is having an effect on our ability to carry forth with our testing of the voting systems. Is it slowing it down? Is it having any impact at all?
I think that obviously doing work remotely does have an impact. Trying to conduct meetings virtually, then it becomes a lot more of a scheduling system or issue to make sure everyone is available. So it has, I guess, created some challenges, but we've been trying our best to kind of move forward and do all the work that needs to be done.
Okay. Okay, thank you.
Thank
And
you.
we'll move on now to NVRA PIO John Conklin and Cheryl Kauser.
Thank you, Commissioner. Just very briefly, a lot of stuff has been covered already. Obviously, the PIO unit has been inundated answering questions about all the changes to all the elections and absentee ballots and all the things that are being impacted by COVID-19. So we've updated all the calendars on the website continuously, the 2020 political calendar, the presidential primary political calendar, the special election calendars, including changes when they were implemented with regard to signature requirements and the designating petition filing period. And we posted lists of who filed the petitions, the objection report, authorization and acceptance reports, and declination and substitution reports all on the website. We also answered many inquiries concerning the designating petitions that were filed, and we continue to pump out FOIL requests. We processed 129 in February and 224 in March. We also participated in all the calls that the executive unit and basically the whole agency has been having with the ECA repeatedly since the beginning of March. Obviously, there haven't been any board visits by the NVRA unit. We have a couple of new grants that have been mentioned by the executive unit. Just quickly, the HAVA CARES grant, which is about $20 million in federal money and a 20% state match. We'll be sending out information and having a webinar with regard to how to submit contracts and vouchers and paperwork to get those funds for the county boards. And also a new grant for cybersecurity remediation. It's about $9 million. The same thing, there'll be a webinar for the counties on how to access funds for that grant as well. And that's really, in a nutshell, everything for PIO. Cheryl, do you have anything you want to add?
Oh, that's good. Thank you.
Any questions for PIO? Hearing none, we'll move on to ITU. Bill Cross.
Good afternoon, Commissioners. While we have a small number of staff on site to maintain systems and provide support, all other IT staff are working remotely in some capacity. We've also worked throughout the agency to provide multiple other staff with remote access capabilities during this time. Projects, obviously we're unfortunately unable to make the May 4th, previously announced May 4th date for Capus Vitus. However, we're maintaining some forward momentum in the current situation and doing load testing, accessibility testing, data conversion. A new date will obviously be dependent on multiple factors. One of the most significant is having staff back on site to do user testing, but also, again, as we did last time, the coordination with the election calendar. Online voter registration, we've continue to make progress in analysis and development of requirements for the OVR and clearinghouse function. The RFQ request has now been completed and sent to OGS for processing. We expect that to be released as a mini bid in the next few weeks. Nice Voter, excuse me, we're also making additional enhancements to Nice Voter to enhance some comparison of affidavit, absentee, and voter history results around early voting. For security, IT, and as John just mentioned, IT and Security Election Centers have staff who worked with executive, PIO, admin, and others to develop the new 2020 Cybersecurity Remediation Grant Program for the HAVA funds, as well as Information Security Consulting Services, or CISO on Demand services to help the counties develop remediation plans and implement security improvements. the WebEx presentations for those efforts will be provided to the counties later this week. We're also continuing to plan a series of tabletop exercises to be held in the July timeframe. We recognize that we may need to adapt to doing that remotely. We are working with partners in DHS, though, to move that forward. The Secure Election Center has also responded to 5 county-related cyber incidents in recent weeks. As of today, all have been restored. We're also continuing to work on multiple security improvements of our own infrastructure, including, particularly for this period, we kicked off a project to upgrade all the county-based connections between the state board and the counties to be completed by the general election. In terms of website traffic, traffic is up this period, approximately double of what normal non-election periods are. 460,000 views for the month on the main website for February, March, as well as 300,000 for the voter lookup site. That's what I have.
Okay. Thank you, Bill. Is there any questions for Bill?
I would just like to point out one with regard to the item that Bill mentioned, the remediation grant program. That is, we talked about briefly earlier. It's about $3 million left from the 2018 federal HAVA grant for cybersecurity, and about $6 million from the 2020 cybersecurity grant that was issued in early January, for a total of $9 million based on the Grant Thornton report that we already did. And our CISO, Jeff Baez, and our IT director, Bill Cross, looked at the common issues in the Grant Thornton report and recommended that grant formula provide a $61,000 floor that's available to each county, and then the remaining money would be allocated to the counties based on the number of voters they had at the February 21st report. So that's the plan that we're going forward with in order to remediate as much of the items on the Grant Thornton report that $9 million will pay for.
Okay. Anything else to add? If not, we'll move on to enforcement. Risa Sugarman. I'm presuming that Risa is not participating in today's meeting, unless I'm told otherwise, which would be consistent with her non-participation for the last, I guess, year and a half of the board. Are there any comments, questions regarding enforcement?
Well, I have the usual questions of whether there has been any activity whatsoever from the enforcement unit since our last meeting. Brian or Kim?
Can anyone answer that? Or
Sorry for the delay there. I had to unmute myself. I can offer up a very categorical answer to the categorical question, which is there's been absolutely no activity that we're aware of, and we remain, I believe, at 0 hearing officer cases for 2020. There were 2 for 2019 and a total of 26 since 2016. So there hasn't been any activity. We haven't sent anything additional over to the enforcement unit since the last meeting, owing to the pandemic.
Thank you.
anything else regarding that? Hearing nothing, we'll move on, I guess. That completes the unit updates. And our next item, it's old business. Under old business, we have the SAM party name. That was an issue that I raised at the last board meeting. I'll just reiterate what it was, that the SAM party, of course, was created in the state last, I believe, 2018 at the general election. Their litigation that they filed related to, I believe it was the Public Financing Commission, indicates that their name is Serve America Movement. We have a prohibition in our statute of using the word American or any variation thereof. And thus, I believe there's an issue of that party using the name Serve America Movement, which is apparently their official name. I raised it at the last meeting. Commissioners Kellner and Spano indicated they want some time to think about it. I don't know if you've had time to think about it and whether you share my concern or have any other thoughts on this particular topic.
My own view is that while they may say Serve America Movement is their name, as far as we're concerned, their records are SAM Party. And I think that that's a reasonable work around the statute. So what's on the ballot is SAM.
Well, let me ask you this then. Let me just ask you this. I know that they filed their party rules in the state using the term SAM, and it was really through the litigation that it became apparent to me that their full name is Serve America Movement. If they are going to continue to function in New York State, can we agree that they would be prohibited from using the term Serve America Movement in literature, campaigning, ballot purposes, anything else, that they would have to continue to only refer to themselves as SAM in order to stay in compliance with the statute?
Listen, I'm in favor of that. I have a problem with all these names, but not as much as I have a problem with independence and independent. But I agree with that if they're going to call themselves Sam, they shouldn't use the other one.
So if we saw them using the word Serve America Movement in this state for, campaign purposes or any political purposes, that we would have them cease and desist using that because it violates our statute? Is that something the commission
I don't know
would
what the
agree to?
legalities are. You guys have to work that out. But I would do that going forward after I told them. I wouldn't go back on any other documents that were there.
And I'm very uncomfortable about prescribing political speech in the future. But I agree that they cannot use the name Serve America Movement as the name of their party. And to the extent they do anything along those lines, I would agree that that's misleading. But I'm not prepared to say they can't ever use the words Serve America Movement in their literature or their public relations. As long as their communications with us are identified as the SAM party.
So you think the statute is restricted to just communications with the Board of Elections as to how they represent themselves, but not necessarily with the voter?
Well, I'm not getting into that because I don't want to necessarily, if they filed rules saying they were the Serve America Movement party, I would agree that they can't do that. And they can't use the word America on the ballot. But lots of politicians use the word America in their literature and have slogans that incorporate the word America. And so I don't want to start getting into a picky issue as to which slogans you can use on your literature.
Well, again, I don't think it'd be a slogan.
I disagree with that. Very rarely do we disagree. I just think that, using America in your literature, ostensibly as a tag or something is very different than claiming you are the Save America movement. That's a big difference.
This is Brian Quayle. I think it's helpful, it's instructive to take a look at what the statute actually says in terms of words. It says that
number?
2124 subdivision 2.
Yeah, I just.
And I would note in that it specifically refers to the word American, although it does go on to later refer to any abbreviation thereof. There's not a lot of case law out here, but there's a bit more case law in the context of the use of the word American or New York State in the corporate context, where they're also banned. And the courts have said pretty repeatedly that the reason for the ban is to avoid the appearance that there's an imprimatur of state sanction. So that if you said you're the American party, it may seem like you were the party that has been designated by the country to be the party. I would note that in the word SAM, Serve America Movement, this is going back to the parts of speech in high school here, that the word America appears to me to be a direct object. And I'm not even sure that it would violate the law if the use of that word Serve America Movement based on the case law that is out there. But I would also note fundamentally in terms of the prescription going forward, that among the words that are banned are the word New York State. And it is very common for every party frequently in their literature and otherwise to use the phrase New York State in front of the name of the party. New York State Republican Party, New York State Democratic Party. So I think that's something we should keep in mind, because that's just two words apart from the word American in the list of words that are banned.
Okay, fair enough. Well, I think the statute either means something or it doesn't. And I think that we should, enforce it uniformly across the board. I just felt that this raised a very legitimate issue when they filed those court papers and identified their name, and that it fit within the statute. I still feel that way. I can see there's some disagreement. And I think if this does become an issue where they're using their name in the state, not the name Sam, but the name Serve America Movement in the state, I think we should revisit it and decide whether or not that's an appropriate use of that term as it relates to a party within New York State law. So I
just want to apologize for not getting cut off. I'm operating here under some technical difficulties.
Commissioner, we're all doing the best we can under the circumstances, so I appreciate that. Okay, we'll move on to new business then. And we already did the ballot access rulings, so we'll move on to B, which is the adoption of Part 6200.2, and that's the post-June primary campaign statements. I believe we did approve that at the last meeting to put out for comment. This is the one that really eliminates one of those filings because of the June primary and the July 15th filing report. There'd be two filings made very close to each other. And we made I believe, regulatory change to eliminate one of those filings. So campaigns weren't filing two filings very, very close to each other. Were there any comments that were received by the board on our submission?
No comments.
No comments. Are there any questions, comments from the commissioners today?
I move the adoption of the resolution that was distributed in the packet.
Is there a second?
I second it.
And it's seconded, and all in favor, say aye.
Aye.
Aye. Opposed, and that is adopted. Okay, so the next item we have some e-poll book updates from our vendors. I believe Tenix, Robus, and NoLink all have an updated version of their e-poll books. I believe, and correct me if I'm wrong, this has to do with the inactive voters and how the e-poll books address that issue. And they did an update to reflect how that would happen. And if there's any explanation of this, I would turn to Tom or Brendan if you want to explain this.
Yeah, the application update for knowing specifically had to do with the inactive voters. Their application update, the only change to their application software was the ability to hide the signature box for inactive voters. So during a check-in process of an inactive voter, currently it does not show the signature, but there is still a spot on the page for a signature box. This application update removes that element from the user interface. Otherwise, Tenix did have a number of different changes to their application, which focus on a variety of functions as part of its use as an e-poll book. But all of them also updated their underlying operating systems to bring them up to the most recent version to kind of ensure that all patches have been updated and that we're on the current version for all the systems.
Okay. Are there any questions related to these upgrades? I believe, and as I understand, we have a resolution that is before the Board
I'm
related to the electronic poll book systems, and if there's any discussion regarding that. Is there a motion to adopt the resolution as presented?
So moved.
And seconded? And
Yes.
the second, and we all in favor say aye.
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 Opposed, so that is approved as well. And that brings us to the next agenda item, which is actually the last agenda item, which is the disclosure. This is campaign finance disclosures at the New York City Campaign Finance Board. And I believe it was to allow those filings that are done there to comply with our requirements so that campaigns aren't required to make two filings. I believe there were discussions between our board and their board trying to make sure that happens in the correct way. And I believe there was a resolution to that. Am I correct?
Yes.
And you're comfortable that the way the filings are being done at the Campaign Finance Board meet our needs?
We are.
Okay. So with that in mind, we would then, is there a resolution here that we're approving? Or
There
is this, okay, hold on. Let me just make sure I get that up. Okay, got it. So, got it. This is 2008?
Yes, that's the right number.
Which is the one we're being asked to approve. So is there any discussion regarding this, or is there a motion?
I make the motion, but I wanted to just add one thing, which is
Sure.
that I first proposed this in April of 2006. And here it is 14 years later that we're finally doing it. And it just reinforces to me that there are some things that can happen that never give up. So
Persistence pays off, Commissioner.
right. I mean, this is to me, this is an obvious efficiency. And I've been pushing for this for a long time, and I'm so happy to see that it's finally coming to fruition.
Okay. I'll take that as a motion. And is there a second?
Second.
And all in favor say aye.
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 And opposed, and that is also adopted. And I believe that is the last agenda item on today's meeting, besides determining if and when we need another meeting. So I guess we need to look at our calendar, and if the staff has any ideas on when another meeting would be required. I mean, under these circumstances, I don't know how much longer we're going to be meeting remotely. Of course, this is not ideal. I think we can all agree on that. But I think it went pretty well today. I do want to say that as well. I think considering this is our first real effort to have a full-blown board meeting remotely, I think it went well. And if we need to, of course, we'll do it again. Hopefully next time we'll be able to meet in person, but under the circumstances, I'm not so sure that'll happen. So is there a proposal of a meeting in May?
I think we should at least pencil in a meeting for the end of May.
Is there a date that people are looking at? The 25th, I believe, is Memorial Day. Are we looking at that week? Is that something you want to do, like the 27th, 28th? Is that something you're interested in, or what are you thinking?
27th sounds good.
Okay.
27th on Wednesday. Commissioner Kellner's okay. I'm okay. So we will, as staff, do you have any thoughts on that? Is there any problem with the 27th?
Give me a second. I don't have any problems with the 27th on the calendar.
Okay, so at this, we will schedule our next meeting then on May 27th at 12 noon. I don't know whether it'll be done remotely or not. Under the circumstances, it very, very well may. But either way, we will meet on the 27th. If there's no other business to come before the board, I would entertain a motion to adjourn until May 27th.
So moved.
And seconded, all in favor, say aye. Aye. And I would urge everyone to stay well and wash your hands and keep safe.
Well, and thank you to the staff, especially
Yes,
for
yes.
they've really put themselves out and especially processing petitions during a very difficult period.
Commissioner Kelly, I agree, and I think we've been remiss in not making mention of that. I think the staff has really done a tremendous job working under these circumstances. I know it's been very difficult trying to work day to day and having people come in, and I understand the staff has been extremely willing to do whatever was asked of them. And under the circumstances, that says a lot about the staff. And I congratulate them for doing the job they've done under these circumstances, because it just so happens this falls in a busy season for this board. And they've had a lot to do. So kudos to them, and I appreciate all their work.
Yeah, I think just one minor, there's a tremendous number of staff that are able to support us also from home because of some of the quick work that we did to bring in the little extra equipment and the work of the IT to allow us to utilize as many people from home as possible to support us. So it's not just the people coming in, the people at home are really working to support us too.
Okay.
Good.
Appreciate that. So thank you, and we will adjourn till May 27th.
Thank you.
Thank you.
Thank you.
Thank you.